Lavanya from Lexis and Company, working as an intern. Today I'll be talking about Section 162 of CRPC. For that, we must know what is Section 161 of CRPC, which requires the person who is being interrogated to respond to all questions with the exception of those that are self-incriminating. Both 161 Clause 2 of CRPC and Article 20 Clause 3 of the Constitution of India provide protection to individuals. Now, what does Section 162 CRPC say? It provides for the limited use of statements and prohibits the court from using them to support statements made in the court. The course of the investigation for the purpose of verification is complicated. The police cannot be relied upon the record of the statement correctly and is sometimes deleted. Now, what is the admissibility of evidence to the police? Any statement recorded by the police during investigation is not given under the oath or verified by cross-examination is not admissible. According to Indian Evidence Act, the circumstances stated there are not considered as factual evidence. CRPC Section 162 prohibits the use of statements that are made to the police during the course of investigation. It is assumed that you cannot rely on the correct recording of the statements by the police or rely on the statements, as the police can record statements for personal gains also. The prohibition of Section 162 is against signing the statements of the witness recorded during an investigation. It stems from the historical distrust in the fidelity of the statements made to the investigating officers. Now, what is the importance of Section 162 CRPC? There are three essential conditions. First, the statements need to be put in writing. Then, the calling of the witness for the prosecution is required, and the textual assertion needs to be properly proven. With the exception of statements made according to Section 27 and 32 of Indian Evidence Act. In case of Tehsildar Singh vs. State of UP 1959, in terms of omissions and contradictions, all judgments made directly or indirectly in the case. However, statements should not be used for any purpose that contradicts him on the witness stand. It showed three typical situations in which omission was considered as a contradiction. If recitation is necessary implied by the recitation of statement, the negative aspect of positive consideration in the statement, and if the statement to the police and the court are not simultaneously true. Therefore, an omission can be treated as a contradiction under these three statements.